Welcome everyone to the Federal Bar Association Key Tam Sections, The Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald. I am programming chair of the Key Tam section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So Tejinder, let's start with some news that involves you. You're headed back to the Supreme Court later this year as part of the relators team in Wisconsin Bell Inc. versus U.S. ex-rel Heath, for which cert was granted last month. We've already discussed this case twice on the rounds as it percolated in the Seventh Circuit. And at its core is a federal program that distributes billions of dollars, but indirectly by a series of steps involving non-government actors. Your client, Tejinder, claimed that the False Claims Act prohibits fraud against such a program, and the Seventh Circuit basically agreed. What has the Supreme Court agreed to resolve on cert?
So the Supreme Court has agreed to resolve is facially a pretty narrow question, and that is whether these specific funds, that is funds under the E-rate program, which is a telecom subsidy program for rural schools and libraries, are protected by the False Claims Act. Basically, whether requests for those funds fall within the statutory definition of a claim. And the court is actually going to end up considering both the pre-2009 definition and the post-2009 definition. There were some small changes to the definition, and the conduct here spanned both periods. So that's what's at stake.
And the case is not yet briefed, right?
No, the briefing is ongoing. It should all be done right around the end of October. And the case is going to be heard in the November sitting.
DOJ sometimes asks to participate in arguments. Give us a sense. What do you think will happen here?
We do expect the government will participate. They haven't confirmed this, and until they file a motion seeking argument time, we won't know if they intend to participate or if they file an amicus brief supporting the defendant for some reason. We'll know earlier. But we think the most likely outcome is that the Department of Justice will participate. They will participate on the side of the relator, and they will seek time at argument. That's in part because the government filed a brief in the case that created a circuit split with the Seventh Circuit. There was a Fifth Circuit case called Shoop, which reached the opposite conclusion from the Seventh Circuit about E-rate funds, and the government filed a pretty vociferous amicus brief in that case, arguing in the other direction, and we expect the government will stay consistent.
So we'll be watching that, and we'll cover that in the fall. Let's move to a case that involves another familiar face, U.S. ex-rel Angelo versus Allstate Insurance Company. A case out of the Sixth Circuit. We first met the relator in this case, Michael Angelo, in our March 2024 episode when he was tangling with a different insurance company. And then in this separate case, Mr. Angelo asserts that Allstate is liable for reverse false claims because it failed to reimburse the government properly under the terms of the Medicare Secondary Payer Act. Allstate won a motion to dismiss Mr. Angelo's second amended complaint, and the Sixth Circuit affirms on 9B grounds with a defense-oriented opinion coming from Judge Chad Radler. Looks like Judge Radler once led the DOJ Civil Division under President Trump. What's your take on this case, Tejinder?
Yeah, so this is in some ways, a kind of down the middle Rule 9B opinion, but in other ways, I would say one that the defense bar would probably like on balance. The opinion is sort of stingy about drawing inferences in the relator's favor. So this is a case where Rule 9B, as we all know, is the particularity rule that applies in False Claims Act cases. And here, what the relator says is that there were certain instances where Allstate was required to reimburse the government, Medicare, for money that Medicare fronted to cover medical expenses that actually should have been paid for by Allstate. And the relator goes so far as to identify specific people who he says the fraud related to. It identifies them by their initials. These are specific beneficiaries. But the opinion is stingy. It says, no, you didn't quite say that they definitely had claims paid for by Medicare. You didn't quite say that Allstate was required to reimburse them. And then the opinion also says, the district court properly denied leave to amend, and doesn't say that the amendment would have been futile. It just says you amended too many times already and you were too late in the day. And so the district court had discretion to say no mas. And so it's a good opinion, I think, for the defense side to cite if they want to make 9B arguments and want to fight against serial amendment.
Okay, let's finally turn to U.S. ex rel. Grant versus Zorn, a case that's fresh from the Eighth Circuit. This was a non-intervened FCA case where the relator won a bench trial against the operator of a sleep disorder clinic. Among other outcomes, the trial judge cited the Eighth Amendment in reducing the prescribed civil penalties from about $7.7 million to about $6.5 million. There were a whole lot of issues on appeal to Tejinder, including statistical sampling, but let's focus on the constitutional prohibition of excessive fines and how it applies to the FCA. The panel found errors in the trial court's Eighth Amendment analysis, remanding with instructions for a downward recalculation. In a long partial concurrence, Judge Smith also found analytical errors, but he came to the opposite conclusion, saying that the original penalties should never have been reduced and certainly shouldn't have been reduced further. Tejinder, many defense side attorneys believe that the FCA's per claim penalty scheme is excessive, particularly in Medicare cases with lots of small false claims. Does Zorn, does it offer a new template for such an argument?
I think it does. The analysis in this case is really interesting. And you flagged that there are multiple issues in the appeal. I'd actually encourage everyone to read this decision. Relators will find much to like in the public disclosure analysis. Both sides, I think, could find interesting stuff in the statistical sampling analysis. But the damages stuff is really where I think it gets most interesting. Here, what the majority does, and the concurrence takes them to task for this, is they import the Supreme Court's due process analysis for punitive damages onto the Eighth Amendment analysis for excessive fines, and effectively say you've got to have no more than a single digit multiplier between the compensatory damages and the amount of penalties, which would be punitive. And so they do a few things. First, they say when you're figuring out the baseline for what the damages are, you shouldn't use the entire trebled damage amount because some portion of that is already punitive. You have to figure out how much of it is compensatory and how much is punitive, and then you use the amount that's just compensatory as your baseline. And then they say you use that and you apply a single digit multiplier. I'll add an important caveat, which is that the majority does recognize that there might be other factors in play that would warrant enhanced penalties. They say if the defendant's conduct is particularly reprehensible, if it's particularly harmful. But in this case, they say really the only thing that's going on here is overbilling. The only damage is economic loss. And it wasn't a ton of economic loss. It was about $86,000 of economic loss, blossoming into millions of dollars of penalties because it came from a large number of claims. And so the majority felt like, that's excessive, and you want a single digit multiplier in a case like this one. So if you have cases that involve simple overbilling, that is no patient harm, no compromised quality of care, stuff like that, all you have is overbilling. I think this case is pretty strong precedent for saying that you're going to be limited to single damage multipliers at least in the Eighth Circuit. Now, as you note, there's a concurring opinion that takes issue with this and says, no, 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 you've used the wrong analysis. The Eighth Amendment analysis is not as limited as the due process analysis for a variety of reasons, and there shouldn't have been any reduction whatsoever.
So, Tejinder, back in 2022, we discussed a different case, Yates, where the 11th Circuit found no Eighth Amendment problem with a $1.1 million penalty on less than $1,000 in damages. Where is the difference between where these two circuits come out, in your opinion?
So I think there are two things going on. I think first, in Yates, the court did not import due process principles to impose a sort of single-digit limit on what the multiplier could look like for total penalties versus damages. Second, I think the court in Yates embraced a slightly broader view of how government programs can be harmed by fraud. That is, it didn't limit its analysis only to the economic loss, but also considered other ways that fraud makes it more difficult to run government programs, could potentially harm patients, and so took a broader view of what the baseline ought to be. And I think that both of those are kind of fair criticisms that you could level at the Eighth Circuit here and say, actually, they've undersold the harm to the government through fraud, and they've used the wrong legal rubric. So I think that, and the concurrence in this case really does stress that point. It tees this up as a circuit split between Yates and this case.
What do you think? Is this a circuit split?
It's splitsy. Of course, there's always fact-specific calculations that you have to make when you're talking about excessiveness because it's such a totality of the circumstances inquiry. But I do think that if you just compare the amount of penalty and the amount of damages, there's a strong argument to be made that these courts are definitely taking different approaches. The majority does cite Yates. It does not purport to create a split with Yates, but I think there's a colorable argument, at least, that there is a split.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association Key 10 Sections, The Rounds FCA News with Tejinder Singh. We'll see you next time.